I thank the Minister for his response, but I haven't had sight of his response, and it is something that I would like to consider carefully. However, I would say this, that, Minister, it seems to me that you're basing this entirely on a certain view of the demands of equality and autonomy, and a certain interpretation of what they mean in this particular circumstance. So what you're saying basically is that you want a pregnant woman to be in exactly the same situation as any other decision maker, in other words, people who are not pregnant. But I suppose the point that I was making to you on the previous occasion was that it wasn't necessarily because of the provisions of the Eighth Amendment that one would have a precautionary provision, that where an advanced healthcare directive was silent about what was to be done in relation to the refusal in an AHD, what was to be done about the refusal of care in the event of pregnancy, that there would be a presumption in favour of continuing treatment, where not to do so would have a deleterious effect on the unborn. It seems to me that while I'm not saying that you are proposing something that is unconstitutional, but in fact I would be very interested to hear what your view of the Constitution now is. Do you accept, first of all, that the Oireachtas is free to make whatever provisions it wishes in relation to abortion and also treatments that might have an effect protective of the unborn, or the opposite? What it seems to me is that one can only really assess what you're doing here in terms of the possible outcomes of the change that you are making. And I did mention the last day that to some degree we all try to avoid the detail of specific cases out of a need for sensitivity when we discuss these kind of provisions. But there is another sense, of course, in which we can only really judge these kind of provisions in the light of what actually might happen in real life situations. And I'm just wondering, have you given consideration to what might happen in real life situations? So as the position is at the moment, no doubt inspired by the Eighth Amendment's provisions, but not, as I say, required solely by the Eighth Amendment's provisions, but by considerations of public policy, that it is this, that if an advanced directive was silent about what was to happen in the event that the person making the directive was pregnant, that there would be a presumption. Now, it seems to me that that is good public policy, because it seeks to protect life if possible. You're taking away that, and what you're leaving us is a situation that somebody might or might not make an application to the court about an advanced healthcare directive. You are leaving open the possibility for healthcare givers to continue to give life-sustaining treatment while the court is making a determination on that issue about the advanced healthcare directive. But you could be talking about a relatively late-term unborn child, if I am not mistaken. So you are reducing the potential protection of a child who might otherwise live. You are doing so in the name of a certain idea of just pure equality. But I think you're not reflecting on the real-life circumstances and what might actually happen. Because you have a situation where currently, under the 2015 legislation, the presumption would be in favour of giving life-sustaining treatment in order to protect, in order to secure the safety and well-being of a child in utero. Now you are proposing to take this away. You are proposing to leave it to the possibility that, quote, an interested person will make an application to the court. What if there's a dispute between different interested persons about what is to happen in that situation, about what is to happen to that child? Secondly, you are leaving it open to the decision of the court, and we don't know which judge might be making that decision, what attitude they might have. All sorts of issues now come into play, all sorts of doubts come into play about what might actually happen. And I put it to you that as a result of this change that you are making, there are children who might have been saved under the 2015 legislation, who will otherwise die potentially as a result of the change you're making, because you're leaving it open to the question of whether an application is made to the court and to the vagaries of what that court might decide. Now, if you are doing that, do you accept, and I'm not putting it to you that you'll be breaking any law, I'm not putting it to you that if you provide in the way you're doing that there'll be some kind of offence that is caught under some other piece of criminal legislation. I'm not putting that to you at all. But I am asking you for consistency between the existing legislation on abortion, which clearly identifies a public policy desirable, which is that unborn children after 12 weeks would not have their lives terminated, and that it would be a criminal offence to have their lives terminated, except in certain defined circumstances which you know, which are proposed to be limited circumstances concerning, for example, treatment necessary to save the life or to the health of a mother, for example, or the case of the situation where the baby is not deemed to be likely to survive beyond a certain period. Those are the limited circumstances where abortion is permitted after 12 weeks. So clearly the law continues to envisage a protection for the unborn child. In fact, some would say substantial protection for the unborn child after 12 weeks. Now you, in a separate piece of legislation, without any detailed consideration or public discussion, are proposing to bring about a situation where there is less protection potentially for certain children after 12 weeks in the womb compared with what is there under the 2015 legislation. What would be so wrong about continuing to have a presumption in favour of continuing life-saving treatment if there is a pregnancy there, and where the Advanced Healthcare Directive is silent on the question of pregnancy? What would be so wrong with that? And the nature of a presumption, of course, is a presumption may be rebutted. So it isn't absolute protection. It isn't an absolute guarantee that the child's life will be preserved. But I put it to you that it is anomalous to have substantial protection for children after 12 weeks in the womb under the abortion legislation, and at the same time to remove protection in the way that you are doing so substantially, so as to leave it that the question of sustaining a child's life in the womb after 12 weeks might depend on whether an application is made to the court and whether the court so decides. Whereas under the current situation, you have a presumption in favour of preserving the child's life. What is it about abortion? What is it that motivates politicians and government and establishment officials to think so little about the possibility of saving a child's life, that you would remove even the presumption that life-sustaining treatment would be continued until such time if there is the possibility of sustaining the child's life?
Thank you, Senator Mullen. Minister?
Thank you, Senator. Thank you, Chair. So again, what we're seeking to do in terms of this provision is to reflect a situation where a pregnant woman will not be denied the benefit of her AHD solely on the basis of her pregnancy, and that is what the current provision allows for. And following the repeal of the 8th Amendment, that is a position that we're moving away from. And I think, with the greatest of respect to the Senator, I think the issue and the core of his concern is perhaps more reflection of the current law in the country on abortion rather than on the current law as it applies to the Assisted Decision Making Act. I think it's important to remember that an AHD does not provide an entitlement to a treatment that's not otherwise available, and it's an expression of the individual's will and preference. And in terms of you spoke of situations of real life. So in real life, a pregnant directive maker is treated as any other person. And persons who have capacity can refuse treatment notwithstanding their pregnancy. That can happen at the moment if they have capacity, and in a situation where they don't have capacity, the content of their AHD will be followed. I think it is important just to recognise, because you spoke about the consequence of non-refusal, of non-treatment, where a medical practitioner followed on from an AHD as a termination. And again, I think it is important, again, the law doesn't recognise that as a termination. The interaction between the 2015 Act and the 2018 Act doesn't recognise those situations where treatment has been withdrawn legally as falling within the definition of termination. But I think it is also important to remember that we do have Section 89 here as well. We have a provision that addresses a situation like you are concerned about, where an advanced healthcare directive is vague, and it makes provision for continued treatment, and it specifically references a woman who's pregnant in terms of that continued treatment as well, and that there's a protection for continued treatment while questions of the validity of the directive is ascertained by the court. So the legislation does make provision for situations where there may be ambiguity. It provides for the potential of continuity of treatment in those situations while the legal issue is addressed.
Thank you, Minister. Senator?
Yeah, I think you actually misunderstand the basis for my argument, Minister. I'm actually not saying that what you are bringing about it would be considered under the law as a termination of pregnancy. Nor am I arguing at this point against the provisions of our abortion law generally. I am drawing your attention to what our abortion law currently provides. And I am asking you whether, and I'm putting it to you, that what you are proposing to do does not follow the logic of it. You talk about equality, but there is no equality between the woman who has a child that has gone beyond 12 weeks in the womb and the woman who is not pregnant in terms of their desire not to be pregnant. The law continues to insist on the protection of life in a considerable set of circumstances beyond at a certain point. And therefore, it is wrong to just look at it through the cold lens of what, strict equality means in every situation, because there isn't a strict equality in terms of the abortion law itself. A person doesn't have an absolute right to be as unpregnant as a person who is not pregnant once the baby is gone beyond 12 weeks in the womb. There is considerable legal protection. So therefore, what I'm saying to you is this: there is clearly a public policy preference around the preservation of life. Arguably, it is rooted somewhere in the Constitution, although there's some views of the Constitution that it's completely silent on any rights for the unborn, and that therefore what the Constitution now provides, if you think about it, the Constitution can do three things. It can permit something, it can ban something, or it can it can mandate something. Now the Constitution, as I understand it, is in a neutral space, because it leaves to the legislature the determination of matters in relation to abortion. Now, we are not talking about abortion here. We are talking about situations where an advanced healthcare directive mandates the refusal of treatment. But of specific concern to me is where it provides for mandating a refusal of treatment, but is silent on what is to happen in the case that the person is pregnant, that the directive maker is pregnant. And I am saying to you that the public policy vision behind even the existing abortion law is such that there is a good involved in protecting human life once it gets to a certain stage in the womb. And what I am saying to you is this: that surely it follows from that the presumption where it is silent should be in favour of protecting the unborn child's life in the womb. That is the point I'm making to you. You make the point that a person who is compos mentis may refuse treatment even if that treatment or the refusal of such treatment has a deleterious effect on the unborn. But that is a different situation, because the person is not silent. The person is in a position at that point to give the direction, whereas they are not if they are not compos mentis. That's the point, and they are silent, at least in relation to one of the sections or one portion of the section that you are removing. So there is a substantial difference between a situation where a person who is compos mentis refuses treatment. They know they are pregnant, they refuse treatment, the law will respect that refusal. I get that. Okay, there's an argument to be made about whether that is disproportionate, having regard to the possibility that there might be a late-term pregnancy or a well-established pregnancy, and that the child might lose his or her life as a result. But I get the fact that the law currently permits a compos mentis person to refuse treatment. But where they have not specified what is to happen in the event of pregnancy, then it seems to me that it is more in keeping with what the law currently provides around termination of pregnancy, which is that you protect life to a very considerable degree after 12 weeks. It is more in keeping that you would continue to have a presumption in favour of protecting that life. That is not asking a lot for an unborn child who might survive. What you are proposing to do is to take away that presumption, and you leave the unborn child in a situation where they are at the mercy of an application being made concerning the Advanced Healthcare Directive, which is threatening them, and subject to getting the right decision around the preservation of their life effectively, because that was what it will amount to from the court. And it seems to me that that is simply not decent, it seems to me. It's not decent to take away a presumption in favour of protecting a life. And it is not decent to do so purely in the name of some kind of doctrinal version of equality, divorced from real-life human situations. Let's just say, for example, you have a dispute among family members about what is to happen, where a person has made an Advanced Healthcare Directive silent on what is to happen if they're pregnant. Okay? Let's say that dispute causes a delay in the bringing of an application to the court. And as I said, the court might not make a decision in favour of preserving the life. Or look at it another way. Why would you put, for example, the father of a child through the grief and the stress of actually having to make an application to the court, simply because you have removed the presumption in favour of preserving the child's life? And you putting your vision, your doctrine, your dogma of equality ahead of the real-life grief and trauma that the father of a child, for example, might be experiencing. Because you're forcing them, aren't you, to have to go and make an application to the court, and to hope that the court makes a decision in favour of administering treatment so as to avoid a deleterious effect on the unborn child in question. I think that lacks decency. I think it lacks humanity. And I would ask you to think about this again. I don't think this has been thought through properly. I don't think this is decent.
Thank you, Senator. Minister.
Thanks very much. I think ultimately and I think it is important in terms of what the Senator said in terms of the protections that apply after 12 weeks. Ultimately, the consequence of the withdrawal of treatment on the basis of an Advanced Healthcare Directive does not constitute a termination under our law. Whether that happens before or after the 12-week period, it is not a termination as our law recognises, and I think it is important that is clearly stated. But on the presumption of care for pregnant women and the fetus, I think to proceed, as the Senator is suggesting, basically that we legislate that a presumption would be made with regards to a pregnant woman who has made an Advanced Healthcare Directive, but one which does not specifically address pregnancy, that certain things apply to her. That would be the creation of a new legal standard, and it would be one specifying the treatment to be provided to a pregnant woman that would not apply to any other woman who hadn't made an AHD. So you are looking to create a very specific treatment of pregnant women under what you're proposing, and it hives pregnant women off in a way that I think we're trying to move away from in the context of this legislation, that pregnant women have the right to set out what it is, what treatment they wish to receive within an advanced healthcare directive. And again, I make the point that where there is vagueness, where there's ambiguity, there is a process set out under Section 89 of the legislation to address that. And I think that recognises situations of ambiguity and provides a mechanism to address them, and makes it clear that the level of care can be provided while that ambiguity is being addressed through a court process.
I think, Minister, you're forgetting something. I'm not proposing to create anything. I'm trying to keep there what's already there. You are the one who is proposing to step down a protection established in the law, which is a modest enough protection, which is simply the idea that the presumption is in favour of preserving life. That's all. And instead, what you are leaving a family with, potentially, is a situation where in already stressful circumstances, they have to go and make an application to the court to dispute or to ask that in the absence of clear provisions in an AHD about what's to happen in the case of pregnancy, that treatment would be given, despite a general refusal in the AHD, so as to protect the unborn child. You are putting the burden, potentially, on some family member to have to go to court in order to vindicate and protect the life of their late-term unborn child, potentially. And I don't think you have... I cannot believe... Well, I don't know what to believe at this stage about what the government thinks about abortion, because things seem to have got so ideological that nothing that could remotely redound to the benefit of the unborn child is to be allowed to be stated in law anymore. And what you keep forgetting is I'm not talking about this being a termination of pregnancy. I'm not confusing this with the law around abortion. I am trying to draw your attention to the standard and the public policy vision that underlies the law on abortion, and I'm asking you to draw the conclusion of that about how we should then treat advanced healthcare directives. And what that is saying is our law on abortion says life has value, and it is saying an unborn child has a right under law to be protected from termination of pregnancy to a considerable degree after 12 weeks in the womb. Well, if they do, surely it follows from that in something not connected with termination of pregnancy, but something closely related that will involve the termination of a life, potentially, that there would be at least the presumption that you would give life-sustaining treatment so as to protect the unborn where the Advanced Healthcare Directive is silent. Now, I know that there's another aspect of it that previously required that where the Advanced Healthcare Directive said even if there's pregnancy, we want to refuse treatment, and the current provision is that you go to the High Court. You're proposing to get rid of that as well. But let's focus on the first one. Well, there is still the possibility of an application to the High Court, but there is a provision being removed that provides that where an Advanced Healthcare Directive provides that even if pregnant, treatment should be refused. In those circumstances, the 2015 law currently provides that that matter would be determined by the High Court. You're also proposing to remove that. I am not addressing myself to that specifically because it is clearly more clear-cut that a person has said, I want to refuse treatment. You're closer to the compos mentis situation that you described earlier. But where an Advanced Healthcare Directive is silent on what is to happen in the case of pregnancy, it seems to me that you should not be removing the presumption that life would be preserved. I don't think this is a particularly ideological end of the spectrum kind of point to be making. I'm sure there are a lot of people who would be proudly pro-choice in their own self-understanding and self-expression who would say, at least let it be the presumption that you would protect life. But because you have an ideological fixation about a kind of equality, you are willing to disregard the spirit of what exists in the abortion legislation, which is that life beyond a certain point should be protected where possible. And not only that, but you are potentially forcing a family into the situation where they have to rely on some other section and go to the court for a determination about the AHD. That is cruel. And furthermore, you are exposing the unborn child in that situation, potentially a late-term unborn child, to the risk that there will be some kind of a dispute, that the application might not be made to the court, or if the application is made to the court, that there will be some kind of dispute and the court washes its hands of it. And all of this I find to be quite callous and cruel. So I would ask you at the very least to say, I will go back and think about this before report stage. I don't think it's a lot to ask.